lien rights. What you need to know. Dave Campbell, if you would begin, please.
And thank you, Dave, for organizing this and putting this together and doing an incredible job of salesmanship in bringing the numbers up to this great group. I hope we can live up to the hype of great and debate on both scores, especially on the debate score. We've got 6 or 7 topics. We're going to compare and contrast Rhode Island and Mass, and on some of the topics we're going to have disagreements as to the best approach to do things. Starting with Rhode Island mechanics lien law, what you should know. I guess the first thing I would suggest about the Rhode Island mechanics lien law is don't try to read the statute. For 70 years, the Rhode Island Supreme Court has requested urgently some sort of clarification of the lien statute to make it a little bit more user-friendly, and that's never been done. Amendments have been passed, things have changed, but it is still an exceedingly difficult thing to read and understand for the layman. Some of the basics, you probably know that a mechanics lien is not available on public projects. It is strictly a private payment remedy for private projects. You do not need any sort of privity of contract with the owner. You can be any tier or level. You can be a sub, you can be a sub-sub, you can be a supplier to a sub, and that does not impact upon your lien rights. If you have provided labor and materials in the improvement of real property, you're entitled to assert a mechanics lien against that property. And it's a technical process, it's a statutory process, and it basically is a foreclosure process. And the steps you don't really need to be concerned with, but some of the basics about the steps you probably should know about. For starters, the mechanics lien was amended about 10 years ago to extend your recovery period to 200 days. So if you're unpaid, and I don't recommend anybody go beyond 2 pay cycles, but if you're unpaid and you need to assert a mechanics lien, the day that you record that lien, your payment period, your recovery period stretches back 200 days. And within 40 days of recording that notice of lien for your unpaid work, you need to file a lien complaint in the Providence County Superior Court, record a lis pendens, and follow some other steps that are similar to foreclosure actions. Serve citations to other encumbrances, and advance, you have a right to advance the case on the trial calendar. It's got priority. Once you file it, you typically will get a trial date before other contract matters on the docket. The remedy of the mechanics lien is not exclusive. You're entitled to file a breach of contract action against the general contractor if you're a sub. The general contractor can see owner, and you can arbitrate as well. So it's not an exclusive remedy, and you don't need privity, and you get advanced on the trial calendar. Another great advantage of a mechanics lien is you're entitled to legal fees. If you are the prevailing party in a mechanics lien action after trial, the judge has the discretion to award fees to you, which is a great advantage. Massachusetts does not have a mechanics lien legal fee provision. Another thing you should know is that in Rhode Island, as in Massachusetts, you cannot, by contract, waive your right to assert a mechanics lien. Even if the contract you sign says you are waiving a right to assert a mechanics lien, you still have a right to assert that lien. It's void and against public policy. And you would be surprised how often you still see contracts that have provisions that call for a subcontractor to waive a mechanics lien. If you have it in the provision, you can strike it, you can ignore it, you can also sign it and still assert a mechanics lien. Another advantage, big advantage in Rhode Island is that Rhode Island is what I would call a double pay state. It is especially friendly to contractors, generous perhaps to a fault by owners' perspectives, because double pay state basically means that the owner can pay the general contractor contract funds for the subcontractor's work. If the general contractor does not pay the subcontractor can still hold the owner, the land, really, responsible for the labor and materials provided. And that's another important thing you probably should know. A mechanics lien under the statute is called an equitable action in rem. It does not create personal judgment or liability against the owner. Your judgment goes against the property itself, like in a foreclosure action. So if you file a mechanics lien, perfect a mechanics lien, and get a judgment on a mechanics lien, you typically will get a foreclosure judgment, which permits you to go against the property. Fortunately, that rarely happens. Typically, an owner is going to bond off a mechanics lien and substitute payment bond for the mechanics lien, so that if you prevail, you'll get a check from the payment bond. Some changes that have been made recently, or somewhat recently. About 10 years ago, the mechanics lien statute was declared unconstitutional as a deprivation of due process. When you file a mechanics lien, it has implications on your mortgage, implications on your credit. You can't refinance, you can't convey, you can't transfer. The Superior Court judge found it was unconstitutional. The legislature made certain changes. One of those significant changes to make the mechanics lien law constitutional and to avoid a deprivation of due process was to provide an owner whose property has been liened the ability to get a speedy hearing on the validity of the mechanics lien. And that would go from the contract validity, the amount that is claimed, you can challenge that in a speedy hearing, and any of the technical steps that led up to the filing of the mechanics lien action. So if the claimant made any mistakes under the statute in terms of notice or perfection, you can get an immediate hearing on that and discharge the mechanics lien.
Can we stop you there?
Yes.
Show your comment on Massachusetts.
Before we get to Mass, just a couple quick comments. Want to mention that there's a very important provision in Rhode Island mechanics lien law that some of you may not know about, which is that if you're a general contractor on a job in Rhode Island, you have to give a notice up front within 10 days. I think it's at the start of the work. Don't hold me to that exact triggering event. But basically, right up front, you have to give the owner notice of the possibility of mechanics liens being filed. If you don't do that, you as a general contractor lose your right to lien the project. Right? A lot of contractors run afoul. Joe, take it away with the Mass lien law.
There was one other thing. I was going to get to the 4.1. There was one other thing I did want to get to. One notice I was going to get to.
But
we're trying to keep
4.1 minutes left. Yeah.
7 or 8 minutes a section. So 4 each.
That's right. That's right.
The only other thing I
Show's on.
The only other thing I have is there's a new provision for retainage liens, which means that if you're owed money on works that were on work prior to the 200 days, retainage on work performed that period, you can still assert a lien for that retainage.
Thank you, Joe.
Okay, I'm going to speak quickly because I'm going to give you a general overview. Here's the things I want you to remember about Massachusetts lien law, and for that matter, extends to Rhode Island. It is the best tool you have to get yourself paid. So be mindful of it. So when your invoices, whether you're a general or a sub or a sub-sub, whether you're a supplier of materials or you supply equipment, or you are an architect or an engineer, all of these services are lienable, if you will. Remember, it's the best tool you have to get paid promptly. Why? You put a lien on someone's property in Massachusetts and you cloud the title. You're going to get the owner's attention immediately because they're going to say to the general contractor, get this lien off my property. Do what you need to do by my contract with you to clear the lien. So most often they turn to the sub or the lien party and try to resolve it. So that's the main point I want you to take away. Don't lose your lien rights. Remember, secondly, it's a time-based statute in Massachusetts. It means you have to act within a certain number of days to perfect your lien or record it, or you don't have a lien. Rhode Island is the same way. It looks back 200 days. Massachusetts, different. Massachusetts says you have to record your notice of contract, that's essentially the lien document, within 3 time periods. The first is 60 days after substantial completion, 90 days after notice of termination, or 90 days from your last day of work. So you have to know where you stand in that. Termination doesn't often happen. Usually it's substantial completion, or it is your last day of work. So if you're at a 60-day cycle in your office and there's an invoice that's not being paid and you don't have a reasonable answer why it's not being paid, call somebody. Call whatever professional you use and determine, should I put a lien on this property? Because it's a time-based statute, you need to act. Once the lien is recorded, you've protected everything that you're owed. Of course, you have to prove you're owed it, but you've protected it. It's not a 200-day look back, it's everything. You then have the lawyer who's representing you, hopefully a lawyer. It's hard to do as a homegrown internal thing. It's almost impossible unless you've done it once or many times to do it right. There's certain steps you have to do. You file a notice of contract, you file something called a sworn statement of claim, which is the monetary claim broken down, and then you file your complaint. You need to do that within a certain number of days. Again, I won't waste the few seconds I have left to tell you what that is, but it is a time-based statute. If there's 2 points I want you to remember, it's the best tool you have to get paid because it stirs the pot. Everyone is going to pay attention to the person who's filed that lien to try to figure out why you haven't been paid, should you have been paid, and the owner wants it off. And the second thing is just make sure that you do it promptly and you get good advice on following the steps.
Joe Craig, do we have any questions regarding liens? Yes.
I mean, the lien can only be filed on private projects, right?
Correct.
And so you mentioned earlier that the payment bond would kick in if you won. Is that normal that private projects would have payment bonds?
No, I think it's abnormal. Typically, it's statutorily required on a public project. That is federally owned, state-owned, or municipally owned. You'll always find a bond there. It's required by all state statutes and federal statutes. So that's protection. On a private project, you typically will only find a payment bond on substantial projects, where there's tens of millions or millions of dollars at stake, because the bond, as they can tell you, costs a lot of money, and they'll pay for it on a larger project. The owner doesn't want to absorb that on smaller projects. It just adds to their cost.
I think the question was about the bond off procedure on a Rhode Island mechanics lien where the bond, it doesn't become a payment bond. The lien bond is a payment bond. Is that what you were getting at?
Well, no, I thought you said if you won the claim, it would come through the surety
Right.
on a payment bond. But
Yes.
I don't see that there's that many payment bonds with private work.
No.
There should be more payment
It's a
bonds.
lien bond that is the same as a payment bond. It stands as security. Surety issues a lien bond to discharge a mechanics lien notice so the owner can refinance or transfer the property, get the cloud of title on it. So that owner wants to clear the title, buys a bond. The bond, lien bond or payment bond, then stands as security for any lien. The payment bond would pay a lien judgment in that circumstance when the owner bonds off.
Please.
Why would a surety issue a lien bond when they know the property?
Well, they issue the lien bond because it's 100%, typically 100% backed. And it is something that the surety does to permit the property to be discharged for a general contractor. Typically, the owner will say to the general contractor, look, at this property has been liened. Your subcontractor liened the general contractor. You've got to get that lien off. General contractor goes to his bonding agent and says, I've got to get a lien bond because the owner's going to terminate me. It's a default on my contract.
And Joe, there's another aspect of it. Lien bond, the premium gets charged every year. So if the case is in court for 5 years, the surety bills 5 different premiums, which they're entitled to do.
So there's a distinction, there's a lien bond, which is the discharge of the lien from the property, as opposed to a payment bond, and that you see on we'll talk about later in the program. It's different.